evidence of those two prior instances of counseling, you already have the reprimand that references those two prior instances. So the fact of those prior counseling issues with respect to Ms. Beatty is already in front of the jury. And I'm assuming that we're ultimately going to get the policy. I think we already put in the policy that talks about progressive discipline. And ultimately, I'm struggling with the concept of, is that really more of a collateral issue? What is that adverse inference going to give as far as a specific cause of action and an element in a specific cause of action? So that's why I'm pretty much against this adverse instruction.
I understand. I think I lack a little bit of I don't know what's going to be. I don't know what was produced last night, or maybe was produced this morning, or is going to be produced. So I don't know what the ramifications of that may be, if anything. So on that factual matter, I think I'd have to defer to Mr. Anderson and Mr. Whitney as to whether this is still in play or might still be in play, depending on what else is produced.
Well, I mean, obviously, and this is why I wanted all the evidence to be closed, so we didn't have to change things on the fly on Monday, but circumstances warrant us not closing the evidence yesterday. So, we might have to make a change on the fly. It won't be the first time we've had to do that.
No, and Your Honor, I think everybody has a word of, if you wanted to take that and set it to the side, and if it's going to come back in, it's easily reinserted with whatever. It would need to be tuned up depending on what the issue, what the missing document was.
For now, I'm going to take it out.
I understand.
And Your Honor, practically speaking, then that will not affect our ability to make the arguments not for adverse inference, but the fact that things are missing.
Well, Judge, we will be objecting to that.
Just experience, but
I need us to stay focused on the jury instructions, and I cannot have us go into 4,000 different permutations of what ifs.
Understood.
We don't have time anymore.
Okay.
I think we're going to, instead of calling it intentional restraint, I think we're going to recast it to say false imprisonment.
Yes, Your Honor. I think we agreed to that.
On the title, you mean?
On the title.
Yeah.
And now there's some language within.
In the body, we had used the standard language about intentional restraint, I believe, on occasions, and then it had a sentence that said this claim is sometimes called false imprisonment. There was a time when we actually had false imprisonment throughout because the plaintiffs wanted that. So I don't have strong feelings.
We're good with false imprisonment, Your Honor, and
I think that takes us to page 9. Was the next highlighting that I saw?
And this is just because I'm not really sure on the false imprisonment that I heard any evidence about hospitalization for the false imprisonment for injuries caused by that or the like. And I'm not anxious to have a lot of things where the jury has to think through about, was there any evidence on something? The judge gave me instructions on this. So there are a few of these where I'm trying to narrow down the description of the damages.
And on that one, I'll go to Mr. Anderson or Mr. Whitney. We've removed some other things in other places, but on this one, I didn't know what the evidence was.
Mr. Anderson.
Off the top of my head, I don't recall that the life care plan had actual hospitalization. It did make reference to treatments and possible inpatient treatments. So that may still qualify. I guess we're talking about wording here. I'd like to leave it in simply because of the details in the life care plan.
Okay, but this is with respect to the false imprisonment claim, not your other claims. So just false imprisonment. Because I think for other claims, this language definitely is in for other claims. But for false imprisonment
alone.
is she going? Is Maya Kowalski going to need future hospitalization? Is there evidence that she's going to need future hospitalization, or if she's lost the ability to earn money because of the false imprisonment?
The 3 days in the hospital.
Well, the problem we have, and perhaps the court is correct, I'm sure the court's correct, that a omnibus statement of these damages elsewhere would cover it, but obviously this is for a number of things added together that totaled up into the entire harm to the plaintiff.
And that's where we're going. He wants an aggregate damage, and he can't have that.
I'm not aware of any evidence, Judge, that's been submitted.
My view of expensive hospitalization, nursing care, and lost the ability to earn money with respect to the false imprisonment, it's not going to come. I'm not going to instruct on it. Now, I will instruct on it in other counts.
Yes.
But for false imprisonment only, I'm going to remove. I need to do this in blue. Okay, the next.
I believe it's the bottom of page 12, top of page 13. It's the same kind of issue for battery. The batteries involved here are Miss Beatty hugging and giving attention to Maya Kowalski that she found offensive, and then the whatever the batteries involved in the incident where the photographs were taken. And again, I'm not aware of a lot of these damages of hospitalization, medical care, nursing care, loss of earnings of money, that there's evidence that would allow the jury to award those.
Well, I think disability or physical impairment stays in. But is there evidence of hospital or medical or nursing care or ability to earn money?
Well, you've got the hospitalization at Arnold Palmer, which I believe we have bills in for. And again, I emphasize, and I confess I don't know this as well. I haven't concentrated on it, but I do have concerns about the defense arguing later, if we take this out, that cannot be included in any further consideration, any further instructions down the road.
Okay.
Judge, we understand this.
Mr. Anderson, we are sharpening our pencil today. There's no more, we're going to write with a really broad brush. We have to get this done. So
Yes,
I don't recall evidence, and correct me if I'm wrong, that because of the battery, Maya Kowalski incurred hospital expenses, nursing care, or the ability to earn money in the future.
Defense concurs.
I cannot off the top of my head.
So for battery, the hospitalization and medical will be out. Nursing care will be out. And the ability to earn money will be out. The language, when I say out, meaning I will not instruct on them. And let's go on to Let's go to page 14.
That I put in because it was your ruling. I was just making,
I'm so sorry, where?
on the bottom of page 14, the officers, directors, or managers was the result of.
No, before we get there.
Oh, okay.
I want to ask, at the end of the top paragraph, that top paragraph talks about what the jury does if they have found a qualifying issue for us to determine punitive or to consider punitive damages. Do we then need a sentence at the conclusion of paragraph 1 that says if you do not find one of those qualifying offenses, you do not consider the issue of punitive damages? So, for instance,
Yes.
I've sketched out the following sentence, if I can read my handwriting. If, on the other hand, you do not find for Maya Kowalski on either false imprisonment claim or the claim of battery on January 6, 2017, then you will not address this additional claim or something along those lines.
And I agree, especially in this case, since it's only involving 2 of the many claims, that would be a good thing to put in there, yes.
Because I want these instructions to be accurate, but also balanced. If we're going to tell them if something on one hand, but if on the other hand, I think we need to have the complementary instructions.
Agreed.
Your Honor, that's fine. And on the verdict form, that's the way they will be directed as well.
Yeah, on the verdict form, we actually we separated them out count by count. It was harder on the verdict form than in the instructions to combine them.
The next additional phrase am considering is in the 3rd paragraph, and it's the second sentence, the sentence that begins, if you decide that punitive damages are warranted.
Yes.
We will proceed to the second part of that issue and then add the following clause. After you finish deliberating. So I propose it to read, we will proceed to the second part of that issue after you finish deliberating, during which the parties may present additional evidence. I'm trying to...
I actually thought about putting that language there and decided it was non-standard, so I didn't type it in. But I agree with that the standard would be better with that.
Any problem with that, Mr. Elegant?
No, Your Honor, I understand what's going on. I'm looking at it to see if they're hearing that, we all know that if they say yes, they're coming back for a phase 2, and that's what you're trying to convey.
I need the jury to understand that if they check yes on the punitive damages, there's going to be another phase to the trial.
Right. They're going to hear more evidence so they can decide that issue.
Because when these are read, they don't really understand there's not going to be a damage line.
Right. And because there is no damage line, I don't want them to be confused as to, well, do I need to add punitive damage money into a compensatory line item?
And so what is the language the court's proposing?
I wrote down after you finish deliberating. I'd have to, type it in to see if it flows properly, but something along those lines. And then I was going to leave in the language I had previously said, the officers, directors, or managers.
Your Honor, I wonder if it should say, after you finish deliberating and return the verdict form, I will give you in a few minutes, something like that.
I'll work on the language, I'll wordsmith it, but the concept I will add in.
Yes, I'm just thinking they'll know, because your comment about, or the comment about there won't be a line on there made me think of that maybe Yeah.
Yeah, so we would like to see something in the event you decide in favor of punitive damages, or however you want to phrase that, you will receive additional evidence.
I'm told the smoke smell is not a fire, it's just somebody with a microwave too long. Okay.
I was getting hungry. I could smell food.
Well, I smell the smoke. That's
Oh, okay.
Yeah, I think, I mean, it does say right after that, the parties may present additional evidence and argument. So
I may cover it.
okay.
I think Greg's right, but I think it's there.
Let's move on. I'm going with the second DCA
Right.
language for definition of manager as opposed to what the defense wants, which is from other DCAs.
I think the defense wanted either one, Your Honor. It looks like that was an alternative.
I'm not going to object and say that one was better than the other. There were two cases and I gave you both.
Well, I appreciate that. Let's see here. That takes us to page, is it 17?
Yes.
The top paragraph. Remind me why this is in blue.
It's in blue because I typed it in and it's my recommendation and I'm pretty sure that the other side doesn't want it. That's why they have the red lines ahead of it. I just felt there's been testimony from Dr. Sally Smith, but there's never been any real, because we're so silent on chapter 39, there's never been real explanation of what role she plays in the CPT and the extent to which the hospital has to coordinate with this. And that's why I put that here in front of the apparent agency part, because it's important that the jury not be confused about that during closing argument.
This is way beyond the evidence.
Well, it's not evidence, it's law.
Well, not the way it's presented.
The first paragraph, I am generally fine with. I think we need to, on that last sentence, remove the word service. So for the circuit.
That's a statutory term, and that's probably confusing, yes.
Well, actually, we probably should change that to zone because that's what the expert testified was the terminology used.
Yeah, I have no objection to a different thing. That frankly, it's always been confusing to me that the DCF circuits and the circuit court circuits are different circuits.
And then I think we need to add in 2016 and 2017 was Dr. Sally Smith.
Okay.
The next paragraph will capitalize child protection team. I was okay with the next paragraph. Now, remind me and talk to me about the excised in the third paragraph, the language excised. When
we briefly discussed this earlier, you had indicated that you weren't bothered about discussing the services in the statute that related to medical diagnosis, but that you felt that the first telephone call had not been made as a consultation under the statute. So there are two references in that statute to consultation. This one that I've left here with the red line excision is one that, I mean, not only do I think it may provide help for the first phone call, but more importantly, I think during what we've heard about the EEG room and all of that, we're hearing conversations that I think also involve a consult. So that's why I wanted that language.
This is the paragraph, as the medical director, Smith was required to be capable of providing certain additional services. Doesn't that confuse what she was doing from the plaintiff's standpoint?
Well, this is taken from the statute as to part of her statutory duties.
Your Honor, I think our problem is how does that go to, I mean, the issue for her is apparent agency, which is not, I mean, it's what the hospital held her out as doing, or she created the impression with the aid of the hospital. And the fact that she has these other statutory duties, in our view, doesn't really bear on that.
Yeah, she wasn't doing those for those reasons.
But for example, yesterday we had a witness on the stand to explain that Sally Smith was in a white coat when she was doing these services, not when she was an apparent agent of the hospital. And that's why we need this kind of thing.
Well, I tend to believe that this blue language is an accurate statement of the law, and it is a instruction that would be required for me to give, so I'm going to give it. The red excised, a child protection team may also provide consultation with respect to a child who is alleged to be abused. I'm going to leave that in. And then in the following paragraph, she was not providing these services as an agent of any hospital. I'm going to leave that language in. Now, when we go to page 18, that's when I start having a divergence of opinion as to whether the balance of those two paragraphs are appropriate. I would rather go back to the instruction I had given in the prior order about the Johns Hopkins. The court's already determined Johns Hopkins made the call to the hotline and they had reasonable suspicion. Whatever the language I used, that's where I'm going to go back to. So I'm probably going to take these two paragraphs out that are on page 19 and go back to the language I previously instructed on.
Your Honor, going back up the line above that, when she provided services in her role as medical director, she was not providing these services to agent hospital. I mean, how's the jury supposed to determine that? I mean, that's almost instructing them that she's not an agent.
I tell you what, Mr. Alligat, I'll think about that a little bit more. Ultimately, what's going to happen, it will probably be sometime tomorrow. Hopefully, sometime tomorrow, I will circulate a draft, and then everyone can chop it up. I kind of figure we're going to be working on this over the weekend, probably via email. Unfortunately, I think that's just where we're going to have to do it because I don't have the ability to. I guess I could convene a hearing on Saturday or Sunday in the courthouse, but you know how unpopular that would make me with all the support staff around here.
I think email works. Your Honor, while we're on this, we're starting to put stuff in from Chapter 39 and so forth. How about one that says they couldn't hold Meyer longer than 24 hours? I mean,
I tried to write that instruction. It's about a page and a half.
Again, when you see what I physically write,
okay,
then you can propose alternatives. But since I'm going to be in control of the document on a going forward, I think it's going to be easier for me at that point because I will know precisely who's made what proposed change, and if I agree, then we can add it or subtract whatever the proposed change is, and we'll go from there. But
for the record, that statute would have given us immunity for a 24-hour window of this, and I tried to write that description rather like I tried to write one for you several years ago on the
Baker Act.
And it just got too complicated to add the 50 pages, so I quit.
Are you suggesting that you can't take what the legislature has written and put it into a instruction I can give to the jury?
On this one for 24 hours, it was just easier to go with unreasonable and unwarranted than to try to get an instruction on that.
Okay, page 18, and this is more a me issue. I have substantial difficulties with double negatives, so we're going to rephrase. In this case, it's undisputed that Dr. Sally Smith was not an employee. So it will probably read something about, in this case, the parties agree that Dr. Sally Smith was not an employee of Johns Hopkins All Children's Hospital.
Okay.
It's just, I don't do well with double negatives.
No,
although I use them all the time, but when I'm looking at it or trying to read it, it just is difficult. That moves us to, is it page 20? I'm assuming this is your comment, Mr. Altenburn. For this claim, the medical negligence must have been caused.
Yes, this is not standard, but I realize because we have all of these other claims in here that where you can get these things, that we needed to explain that the traditional medical malpractice is a physical injury.
I think the standard's going to be okay, so I'm probably going to excise this language.
Well, is Mr. Anderson going to be able to argue that the medical negligence has caused emotional stress because of various things not related to misdiagnosis or treatment of CRPS?
Well,
Isn't that for the jury? At some point, the jury gets to decide something.
I'm going to go back to the standard and instruction. Now, I know, and again, and I will preface this when we talk about the negligent infliction of emotional distress, I know the defense does not want this. It does not believe there's evidence of it, and we have that multiple directed verdict motions. And so I've made the decision that we're going to include language in the instructions and the verdict form. So given that we're operating in that parameters, I would not find any waiver by Mr. Altenburn talking about this claim and agreeing to language in this claim because it's clear I have made a definitive ruling. So
thank you.
Is that enough protection of the record so we can just actually talk about?
It is for me if it is for Mr. Elliott.
Yes.
Now, I think what I should do at this point is add the language that is proposed in pink, interacted with Jack. What I'll probably say is interacted with Jack or Beata Kowalski or both. I think that's probably a little bit more accurate. On page 23, I think I'm going to remove the statement, you may not rely on evidence that she heard about an incident from another person when she did not actually see or hear the incident herself. I'm going to remove that. And again, I know specifically that's something that the defense disagrees with. Now, with respect to page 24, I do think that there would be evidence of expensive hospitalization in medical as well as nursing care and treatment. So I'm going to leave that language in. Let's go to page 25.
Your Honor, if I can just ask on the interacted with language.
I'm sorry, what page are you on?
This is the top of page 22. The manner in which it interacted with Jack or Beata or both of them language. If we're doing that and they don't have a physical injury, I guess I'm concerned about what you're going to do in the verdict form for this, because normally there's a finding of, if they're combined, there's a finding of negligence for the first party on instructions on that, and then there's this claim. And I'm only kind of bringing up, I think this creates issues on the verdict.
If you think that we need to have a further interrogatory finding based on the court's ruling on allowing this claim to go, I certainly would be open to that discussion.
Your Honor, the one observation I would make is, because I know this came up late yesterday on pertaining to this, is that, Beata did die. That's kind of the ultimate physical injury.
But that's never been alleged as this or a part of this at all.
I think there's issues. There's certainly case law that talks about negligence with respect to suicide and how that's very, 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 very limited on circumstances that, like inpatient or where there's a duty. And so I hear what you're saying. I'm not sure, though, that the death itself is qualifying, given the status of Florida law on the duty issue and negligence relative to suicide. So, unless there's something else, I'm on top of page 25.
And the problem with this is that this is a special had to be pled, and it wasn't pled for this count.
And what says the plaintiffs?
I thought these were in the initial and repled facts. I need to get my 8th amended out.
My recollection is this issue was not pled for this count. So for now, I'm going to remove. If you can point to where it's pled, I can certainly add it back in. But for now,
Your Honor, if I could, we're on 6C, right? Paragraph 117. These physical injuries and manifestations of psychological trauma included aggravation of her CRPS. Paragraph 117 of the 8th Amendment complaint.
Let me pull it up.
Well, it continues on, weight loss, worsening lesions, and so forth.
Okay, so this is at DIN. What DIN are we at?
Ooh, 2816.
He is right that paragraph 117 does say these physical injuries and manifestations included aggravation of her CRPS. I was looking at page 1, on paragraph 123 in the wherefore clause for something in the request for damages that included aggravation, and
It has to be in there.
I did not see it there.
Okay, well,
Doesn't it have to be in the wherefore?
perhaps when I was looking at it, I was just looking in the
Well,
wherefore clauses.
my position is it's supposed to be in the wherefore
Yeah.
clause, but
Well,
That's
where you ask for damages. But.
Well,
in an ideal world, yes. But if we're talking about the question of notice, I am now looking at paragraph 117. So I'm going to change my ruling, and I will keep in the discussion of aggravation or activation at this point. Okay. Keep in. Now let's move on to the negligent training issue. And I guess, has the plaintiffs changed their position at all on this, or are they still riding this horse?
I think we want to ride this horse a little longer. There's always JNOVs and other ways to deal with it, Judge, but I remain concerned that you never know what you don't know.
Well,
I will defer to the. Oh, sorry.
I have detected a shift from negligent training of doctors and healthcare providers to a more generalized staff. So let's talk about that, because my inclination is to keep it to as it was pled, which is more along the lines of negligent training of doctors and healthcare providers.
Your Honor, staff was pled, and and again, I didn't hear this part of the testimony, but the reason we added it in here is because I understand there was some contention made that Ms. Beatty was not a healthcare provider, but was just staff.
Okay, well, can you give me a paragraph?
Oh, where staff is pled? Yes.
In this count, there were references to staff, but this count was this thing that had several different theories in it throughout. And that's been the problem when they started dropping this and dropping that. And, negligent training of doctors is a medical standard of care. Ms. Beatty is a professional, but she's not a healthcare provider.
She's not.
And I'm not sure, I haven't heard anything, there are complaints about the people in the cafeteria.
Well, and then let me, and I know this is forecasting what's going to happen on Monday, but based on the discussion yesterday, if this joint commission finding of whatever it was, immediate jeopardy, and I think Mr. Whitney told me yesterday that the finding was based on a systemic issue at the hospital having to do with patient safety and organization and stuff that was not just failure to, he might have even said that there was a failure to train folks at the hospital as discussed. I mean,
he did those opinions. I agree. I heard it yesterday. I don't think it should have come in. And all that discovery was done because you allowed it for evidence on the punitive damages claim at the end of the summer. This wasn't done because they needed more on this claim. They were ready to go to trial on this claim, they said, a year ago, April. And so I was listening to that yesterday trying to figure out what it was really relevant to.
I don't want to get into it because there's so many issues associated with it, but if this report comes in or some discussion about the report, I'm having to, in my mind, envision how the jury instructions are going to look and what the evidence is going to be. So, I'm somewhat handicapped because I think all of you know exactly what's going on, and I'm the only one left in the dark. So,
we have a pretty good idea now, Judge, but we still await the defendants providing of documents that
that's
we're supposed to receive.
Supposed to happen this morning, and then the deposition is going to happen tomorrow.
That's correct, Your Honor.
Yeah.
Documents will be given this morning.
So I'm just in my mind having to formulate what the possible evidence is and how it impacts. And out of everybody in this room, I'm probably the one with the least amount of knowledge. Maybe, Ms. Krause, you probably don't have the same knowledge as everyone else. But
I have some knowledge.
I know some, but probably not the deep history on this issue.
She probably has more than I do.
Well, yeah, you probably also, Mr. Altman, probably don't have it. And Mr. Elegant probably doesn't have it. But
I'll confess, Your Honor, while we're on this staff thing, paragraph 193 in 14C incorporates some earlier paragraphs, among them 170, which is a part of 14A, and 170 refers to competence of its medical staff and personnel. So, again, we did plead staff. Plaintiffs did plead staff. And again, it continues on later when we talk about staff and some subsequent allegations that are incorporated. So that's why that came in. And again, I think I just heard this morning that she's not a healthcare provider, she's staff. So
we're sitting here.
She's never been a healthcare provider.
For the record, we moved to collapse the pleadings into the proof on that count.
But we're sitting here at the end of trial. Everyone has rested, and the plaintiffs have not provided something that would provide a training theory for the doctors as professionals under a medical standard of care by the medical committees that you believe may be responsible for this, and a separate one for staff who are negligent, and they're citing cases about employees who are outside the scope of their employment or otherwise someone's not liable for as an employer. So I just don't know where to go with this, so I'll stop.
Anything else, Mr. Elliott, that you?
Your Honor, I have no problem with putting some language in, if it's not already here, that says, if you're looking at the medical, please refer back to what I told you about medical malpractice standards. There's no problem with that.
Well, for now, what I'm going to do is keep in the reference to staff. And if someone has objection to the language that I send around, hopefully tomorrow, I'm confident that you will, in legislative format, showing the strike-throughs and additions, any sort of proposed changes. I think on page 26, I was going to leave in the pink language.
I do not have pink language.
It's shaded on ours, I think, Mr. Anderson. We did lose.
Yeah,
It looks pink to me, but
the pink is only because I put a comment off to the side pointing out that I thought it demonstrated the problem with the whole concept.
but it's right now I'm keeping that language in.
Yeah.
Okay.
And then the highlighted on page 27 in yellow, and pink and yellow, I was going to leave in, and I would leave in the staff reference as well. So I think that takes us to
I think the next thing is damages on fraud. Page
the
29.
fraudulent billing.
Yes.
But I mean, your comment was, I took it to mean, you just disagree, but now that I've ruled.
Well, I think the comment maybe reads longer than I've got that it's on the screen. That not only they failed to prove, but I mean, yes, his policy that year came with a deductible, and when he was on the stand, he was asked about whether this deductible would have been paid for all the other things that went on in his family during that year, and he had no idea. And from looking at the Aetna run that's 900 pages long for these 3 years, it looks to me like even if you cut out all of everything from the hospital, the deductible was going to be gone. So there's no evidence that there was a deductible that he was damaged by, and he produced no payment whatsoever of a copay from any account, nor did he claim that he took it out of his billfold and paid it that way. So that none of that is here.
I understand that you believe that this claim shouldn't go. I know that. I've ruled otherwise.
Okay.
But so the comment, I think, was more of a renewal of the DV motion as opposed to an alteration of the
That's
language.
correct. If there were proof of all these things, they could be on those lines. And but on the, I'm not quite sure what we're doing with the lien. I agreed that they didn't have to prove damages of that, but I don't know what the jury's going to do if they get a decision about any increase in insurance carriers' lien rights against the plaintiff.
Yeah.
How are they really supposed to do that?
Now, on page 30, where there was about 8 comments, that's kind of where I started getting lost in what you all are trying to say. So let's talk about page 30. So who wants to go first?
Your Honor, I think this isn't quite traditional, but I think in terms of dealing with a lien and the amount of a lien and so forth, that number C, that is something that we understand the court would typically do after the fact. So in terms of that part, I think we're okay having subpart C come out.
How about the pink language in A and B?
Well, we were just talking about that, and you said that that you were going to leave that in. So
Yeah, there was just too many comments there for me to.
I understand.
That's why I was trying to. Okay. So now we go to the intentional infliction of emotional distress survival claim. So I guess I'm not going to be as crisp because this is later in time and I've somewhat run out of time in my prep. So
That's okay.
I think we're going to
probably need to discuss.
we're going to have more discussions about
Yeah.
the next few comments.
On that first paragraph, I think we agreed that we were going to use the language during the time that Beata Kowalski was a patient at the hospital. Am I correct, Mr.
Yeah,
Elliott?
that's fine. That's fine.
So the blue
Yes.
and pink language in that paragraph you all agree on?
Yes.
Okay, so then that takes us to the next page. Am I correct, or is there anything else?
That's correct. The blue language on page 31.
Now, in let's see, what was sent this morning?
The only thing I sent, and I sent it shortly before midnight, I'm sorry, was an effort on the suicide claim to put together something that would have both of those.
Okay, so that's a wrongful death, not
That's the wrongful death. That's
so
not.
I'll put that to the side and
Yes, there's no change in what. And here, what I've pointed out is, if there's been all kinds of evidence in this case about maybe a negligent violation of the statutory Bill of Rights language or some internal policy, or that we didn't put her name on a door, and all of these things that they're being complained about, but they're not things that, if analyzed, would go to a jury as extreme and outrageous conduct without regard to whether it wasn't even intended to create severe emotional distress on the part of Beata Kowalski. And so because there's so much of that in this case, there needs to be something that explains to them that there are some things they can't consider for this, and a better description of what they can. And this was my effort to do that, because again, normally there's an incident, something that's a big trigger event that causes this in the case law, and this case doesn't have the big trigger. It's just got things going on for 100 days in the hospital.
Yeah.
Mr. Elliott?
Your Honor, my comments are there in red that, this is, I think the jury hears this and they're going to basically hear the court telling the jury, there was just no big deal here. This was
For the
stuff wasn't important.
side.
Well, Mr. Anderson, I can only have one person talk at a time.
Yeah, we just think, these paragraphs are jury issues.
It is all contextual is the problem, Your Honor. It's all contextual. Any one of these things, pulling isolated facts out of a storyline and saying, well, we just think because we're, I guess not the jury, that we should ignore this and then you should ignore that. This is completely and utterly for the jury to decide, and telling them what they should consider to be outrageous under those circumstances is invading their province. I object strenuously to anything that does that.
So let me point out.
And this is a rather key count.
Yes, and this is a key problem. And let me just use one example, if I may. The lady that my partner here so nicely explained had a nice hat. She came into the hospital and didn't register and was bringing this semi-sanitary icon into a hospital room. Let's assume that was negligence on the part of the hospital to let her get in. But you can't take things that aren't themselves extreme and outrageous conduct. You can't take 14 little negligent things and say, oh, that equates to an extreme and outrageous conduct that intends. That's exactly what they're trying to do. This whole context is to tell this long story made up of things that individually cannot possibly qualify for this, and then say, well, but if you put them all together, somehow they become an extreme and outrageous conduct. And that's just not the law. And the jury needs to know that.
I thought we had this decided when the court ruled on the directed verdict motions and on the summary judgment motions on these exact same arguments.
It was found that there was sufficient evidence of extreme and outrageous conduct to go to a jury. I just think that there's a pile of things that aren't that they need to understand aren't that.
Because,
Folks,
Yeah.
give me a chance to reread this, please.
Yes, sir.
Let me tell you where my head's at, and then I'll let everybody respond. Out of these 4 paragraphs in blue, I think I would go with the defense request number 3, but not 1, 2, or 4. So my current thinking is we would only instruct as to paragraph 3, which would include that sentence that fragment of a sentence that is underlined as well. So that's kind of where I'm at. So, Mr. Altenburn, why don't you?
Your Honor, I mean, the whole reason I put that paragraph in was because I didn't want what's in the underlined language to be sent to the jury as an explanation. I mean, if you're going to add the plaintiff's language to that paragraph, I'll withdraw the request for that, because things that were relayed by her, things that Maya Kowalski told her father that may or may not have been entirely accurate, she's 9 years old and upset, that he takes home in this game of telephone tag, and he tells his wife, and he can give us a general description of it, but we don't know exactly what we said, and we don't really know how she responded on that day because she's never been able to testify about that. How can that be evidence that makes the person in the hall that was doing these things that got them upset? That's extreme and outrageous conduct intended to cause Beata Kowalski severe emotional distress. This telephone line is the exact reason why a lot of this stuff can't qualify for that. So if you're going to add that language, I just want to, if you're not giving the rest of it, I would withdraw it all.
Mr. Elegant, you heard my thoughts that I was thinking about doing 3, but with the underlying. Now also qualify that with Mr. Altenburn's request to not have it at all.
We're fine not having it at all. I mean, Your Honor, all the extreme stuff is defined immediately above that in 410.4, 5, and 6. I mean, it's all covered how bad it has to be. So we think the standard instruction covers it.
As long as Mr. Anderson doesn't argue that he can take 9 negligent acts and turn them into 1 extreme and outrageous act, that's fine. But he's not going to argue that when this case is closed. So, I mean,
I'm glad
to
you're
make it
writing
clear,
that closing for me.
well, I've heard your trial. I'm sorry, but again, I want these, but if that's the ruling you're going to make, I'm going to have to say that I have to withdraw them, because it's worse to give them than to have them all denied.
So
Agreed. Withdraw.
So given my ruling that I would do the number 3 with the inclusion of that underlying clause, you are saying you want me to remove number 3, and it sounds like the plaintiffs are okay with number 3 being removed, so I'll just cut it totally.
Okay.
So was there disagreement as to that last paragraph?
Oh, the final language is that I don't think the concurring cause language that's standard, that they gave enough thought to this being a stress case. And so the language, extreme and outrageous conduct may be a legal cause of severe emotional stress, even though it operates in combination with the act of another. I think it's clearer to the jury to say, even though the act of another or some other cause also contributes to the stress, because I think that's what they're trying to explain.
We want to stick with the standard language.
Mr. Elliott?
Yeah, Your Honor, as my note on the side, as Mr. Anderson says, we want to stick with the standard. I mean, I quite frankly don't. I mean, grammatically it's different, but I'm not sure how much different it is in meaning.
Okay. Well, I'm going to stick with the standard.
Okay.
On page 33, the pink box. Am I reading that the parties agree?
I'm sorry,
Pink
which word?
box.
Which page, John?
Page 33, under the instruction, which is 410.7.
Oh, yes, Your Honor.
The phrase, during the time that Maya Kowalski was a patient at the hospital.
Yeah, I think we all agree on that.
Yes, that's good.
Side note says that Mr. Elliott says it's okay.
And I do.
So that now we're going to the intentional infliction of emotional distress, wrongful death claim. Unless there was anything else on the survival claim.
No, Your Honor.
No, I think that's right. And as Mr. Altenberg noted, he sent some stuff over this morning that it kicks in at one point here, and that may be easier than trying to work through some of this once we get to that point.
I agree.
Well, it looks like that starts at 410.7. So
I think so.
I had made the same request on concurring cause, so I'm assuming you're going to stick with the standard language here as well.
I'm going to go with the standard.
Okay.
So does that take us to 410.7 or?
Yes, I think it does.
I think so. Yeah, I think all that stuff in red then comes and all comes out. Everything before from there on down to 410.7.
For the record, I had wanted what is in the current instruction, but once there's a ruling that it has to be dual, it just doesn't work. So
let me
I tried to put this
reread
together.
this alternative language that came in, I guess, at midnight. Just give me a second to read it again.
Yeah.
So if they find no on that, then
Read this. Mr. Altenburn, is there anything that you want to tell me about this language? And I'll go to Mr. Elliott as to his thoughts about this language.
Well, at some point, I do want to explain to you, why it is that I think we need to have more on foreseeability if we're using the substantial factor test and explaining in a little more detail why I still believe that's a mistake. Because until your ruling in open court earlier here, I had at least assumed that we were making a substantial factor meaning irresistible impulse. And so it won't take me long to do it, but I need to try to do that.
Sure. Go ahead.
You want me to do that now? I'm happy.
Might as well.
Okay, so I've cited the cases we've discussed before and taken quotes out of them. And so in describing these, the case law always goes into the importance that there's qualitatively something different about foreseeability here as well as causation of suicide. And while I don't actually, I've gone through a laundry list of options with you, all of which have been rejected about what the intent should be, but we're down basically now to the remaining irresistible impulse is more or less the same language that the plaintiffs requested initially out of Nelson. Nelson is under FELA, minimal negligence language, but it's the only thing we have in Florida. So if we're going to use that, I've tried to put this in here in the context of a tort that is designed to only hit suicide on the rarest of circumstances, which FELA law is if there's any negligence, you win. So that language has been adjusted there. But the problem with the substantial factor test, and I was thinking about this last night, but as an example, I have an uncle, Edward Gann, Mondayman, Iowa. He was a good Catholic. He was a husband. He had 2 boys. And many years ago, he committed suicide. He had been on a crew of a bomber that got shot down over Germany during the Second World War, and Adolf Hitler's army put him in a concentration camp for an extended period of time. He did not commit suicide until many years thereafter, but I will tell you right now that I believe that Adolf Hitler's army was a substantial factor in the suicide of my uncle, and I will believe that viscerally until the day I die. That's an emotional feeling on my part, and maybe somewhat moral feeling on my part, but it's not a legal duty. And the reason that we have made suicide something that we place the duty upon the person who does it, that we make it an independent intervening cause, is because there are many public policy reasons to do that. The legislature hasn't recognized this tort, and so far the appellate courts of Florida have not. And there are reasons we do that because, again, I checked last night, the CDC estimates that in 2022, there were nearly, I think it was 3,400 suicides in Florida. I guarantee you that at least 2,000 of those families who lost a loved one will tell you that they're not going to tell you, well, it was all his fault. He did it. It was an independent intervening cause, and it's all over. As human beings, the first thing we think about when someone commits suicide is, well, what caused that? What was the trigger? Why did Mr. Bill do that? And that's, I think, good therapy for us to try to search for those things, and as from a preventative standpoint, something that the government should work on to try to keep people from committing suicide. But the Kowalskis clearly think that DCF was a substantial factor. They think our client was a substantial factor. They even probably think that Judge Hayward was a substantial factor. And I'll tell you clearly on the record that Judge Hayward played absolutely no part whatsoever in what we're dealing with in this case. But if we have an instruction that goes to the jury and that says on the verdict form, we've modified this, that the did John Hopkins All Children's Hospital, through the intentional or reckless acts of its employees, engage in conduct was sufficiently extreme and outrageous that it caused Beata Kowalski, excuse me, I'm reading the wrong one, that did the employees commit extreme and outrageous conduct that was the legal cause of severe emotional distress that was sufficient to be a substantial factor in Beata Kowalski's suicide? If we ask the jury that, just like the 2,000 families who have to believe that it was something else that at least something was a substantial factor, that's the analysis they go through. That isn't the law now. It shouldn't be the law. And so I believe that we should not give this, but if we do, we need to emphasize at least that for the law, this has to be something that's foreseeable, where the person can say while they're doing the conduct, yeah, you know what, this could cause him to commit suicide. So what? That's reckless disregard. But unless we have something very, very strong on this, when we give them this thing on the verdict form, they're going to do exactly what those 2,000 families did last year in Florida. And we'll have lawsuits down the road. Not just this one now, that's the first in Florida. We'll have lots of lawsuits about this if this becomes a law. So I want a jury instruction that's as strong as possible, at least, even though, frankly, I guess if one is weaker, it's better for me on appeal. But I feel obligated to get one that's as strong as possible.
Mr. Elliott, on the comments that Mr. Altenburn just made, any response?
I'm a little unclear. Was that going to the part that talks about the second test you will apply?
Yes.
Okay. I don't think we have a problem with the wording of the paragraph that starts the second test. I have some issues with some of the stuff above.
I guess I'm talking about the more generalized comments that Mr. Altenburn, before we get to the specific language. I mean, he's looking at this, and his argument was at the conceptual level.
Well, yeah, we talked about that before, and I mean, there's some things that I would do differently. I mean, we had talked about whether it could be a rational decision or not, and that's not in here, and I'm not going to ask for that. I mean, I suspect we've all been either families or friends that have been touched by suicide, and it's a tragic situation, and it's but I think here, I mean, the jury will decide if it was a factor or not, and I don't think it's automatic. I mean, it'll be based on everything they've heard. So, the way the verdict form is going to be broken down, we'll have to see what the exact questions are, but there's going to be one question for the irresistible impulse, and there's going to be one question for the substantial factor. And so later on, and I think you already said this yesterday, later on, if the appellate court decides it's one and not the other, then they'll have the guidance to sort through that. So.
Well, let me just make a couple of observations about Mr. Altenburn's comments, and then we'll get to the specific language. What I'm hearing Mr. Altenburn effectively make is basically a slippery slope that we're going to open up the floodgates to and basically energize a previously almost dormant cause of action, and under that cause of action will now recognize a whole panoply of situations that previous to today Florida law didn't recognize. I think I just want to push back and disagree with the fundamental premise. First, we're talking about intentional conduct, not negligent conduct. The case law already builds in a check on the issue of whether the conduct itself is appropriate for taking it to the jury. As we all know, under the Stedman case from the second DCA, the element of outrage is an issue of law. And I think that's a very important safety valve in the intentional infliction of emotional distress, because it allows a trial judge right at the beginning of the case on a motion to dismiss can weed out any claim that does not rise or doesn't plead facts such that the conduct does not meet the intentional standard, the outrage standard. For instance, when I was assigned to the parents of the Gabby Petito versus the parents of Brian Laundrie case, the very first motion that I heard was a motion to dismiss the intentional infliction of emotional distress on a claim that the facts did not rise to the level. And obviously I disagreed and I denied the motion to dismiss, but the point is the check of the emotional or the conduct is something that the court can address right off the bat. You don't have to do any discovery on it, and it doesn't open up floodgates. So I just would push back because I think the existing case law already builds in the protection against what Mr. Altenburn is effectively trying to argue. Now, it breaks my heart to hear what happened to your uncle, Mr. Altenburn, and there are countless number of families, both in that war and other wars where there's just brutality. I actually would consider what Adolf Hitler did to be probably the most outrageous I've ever seen in recorded history. So I think his conduct would qualify under Florida's intentional infliction of emotional distress. And, under a substantial factors test, I think your uncle perhaps would have had a cause of action against the Third Reich and Adolf Hitler. But that is besides the point. I do believe that Florida law does recognize the substantial factors test as well. And so I do believe we're going to keep it on, or we are going to keep it on. So having said that, let's get to the specific language in these instructions. So, Mr. Altenberg, do you want to talk about specific language?
Well, I mean, I started off I don't think the first paragraph is in any different. You had wanted and ruled that you wanted the sentence that John Hopkins did not need to specifically intend the conduct of its employees to cause Beata Kowalski to commit suicide. So I've placed that there. And then say that, however, the employees of John Hopkins All Children's Hospital needed to engage in extreme and outrageous conduct with the actual intent to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress. I put that in there because we jumped from a finding in the previous count. This instruction doesn't have the issue language about the intent to cause the severe emotional distress, and especially if we have the sentence about what it is they don't need to intend, we need to repeat what they do need to attend.
Do you mean and act?
Yeah, extreme, and she says I've mistyped something here.
However, the employees
To engage in extreme and outrageous conduct.
and missing a word and. Is that what you meant?
Yeah, the act should be and with the actual intent.
Okay, and
with the actual
Okay.
intent. And I believe that's a correct statement. And should be given. And then I jumped to, in most circumstances, the law treats an act of suicide as unforeseeable and requires the person to be responsible for their own act of suicide. That's a true statement of law, and once we're going to jump to this one, I believe they need to understand that this is an exceptional circumstance, and that provides that. So as a result, in order for the hospital to be liable for the death of Beata Kowalski, you must find that her suicide was a likely result of conduct of the hospital's employees, which is probably more generous than I would like, but I think that follows the turquoise language, and then I follow this with there are two tests that you will apply to decide this issue. First, you will use a test called the irresistible impulse test. I'm explaining this a little bit more because it's unusual to have two tests. I think they need to understand that. Because responsibility cannot be placed on someone for a suicide committed by another person who could reasonably be expected to resist thoughts of suicide, this test requires you to find that Beata Kowalski committed suicide as a spontaneous decision brought on by an overpowering urge or desire. And that is right out of the standard English language definitions of something that is an irresistible impulse. The extreme and outrageous conduct must have driven Beata Kowalski beyond the point where she could rationally decide against killing herself on January 7th, 2017. And that's based on the language that actually the plaintiffs requested earlier out of Nelson. The second test you will apply to decide this issue is called the substantial factor test. When someone causes another person to suffer from severe emotional distress, that stress is not always enough to make the person who causes the stress responsible for a suicide committed by a person who could reasonably be expected to resist thoughts of suicide. That sentence is too long, but I couldn't manage to shorten it last night. This test requires you to find Johns Hopkins All Children's Hospital is responsible for Beata Kowalski's suicide only if you find that the severe emotional distress created by the conduct of the employees of the hospital was a substantial factor in bringing about her suicide on January 7th, 2017. Now, I've not included a definition of a substantial factor in this. I suggested some before, but frankly, they all went back to irresistible impulse. But I do believe that if the court is going to do this, there ought to be some definition of a substantial factor. From the case law, I just didn't quite know what to do.
Mr. Elliott, anything?
Yes, Your Honor. I think we're fine with the first couple paragraphs. I would say my main concern is the words in the fourth paragraph, the paragraph that starts there, two tests, where it refers to a spontaneous decision. That we don't see that in any of the case law, and really logically it doesn't make any difference. If these things happen over time and it builds up, I guess the decision when you ultimately do it is always spontaneous. But the concern we have here is that the defense will go in and say, "Oh, well, look, she thought about this for a day, or there's evidence she thought about it for a day, or whatever." That should not relieve a defendant. If the defendant does cause it, or they are a substantial factor, or they lead to it, that should not relieve the defendant because the person waits a day or some period of time. So the spontaneous decision we really object to. The paragraph that starts in most circumstances, I mean, that's basically just telling the jury some law. I don't know, and it's sort of repetitive of what comes after it anyway. I mean, in order for the hospital to be liable for the death, you must find her suicide was likely conduct of the hospital's employees. I don't think we're offended by that, although it is again repetitive. I mean, they're told several times in this and above it that the hospital has to have been responsible or been a contributing, substantial cause. So I think those are the main concerns I have there. As far as trying to define substantial, as we pointed out in the other set, I mean, the standard jury instructions that they say in the comment, we use substantial because it's a commonly or substantial or substantially because it's commonly understood. I don't think it needs a further definition. I mean, obviously we could look at, something, but I mean, I think it speaks for itself. And there's, they even cite to like a really old case that came out the year I was born for the definition. So, or the reference.
In response?
Let me tell you what I'm going to do, and then I'm going to give everybody one last chance to say anything. When it comes to the intentional infliction of emotional distress, wrongful death claim, I'm not going to announce. I'm just going to adjust the language and send it out. I think it's going to be easier for me to do it that way than trying to articulate here with all these different pages and whatnot. But if there's anything else you want to tell me about intentional infliction, not the damages, we'll talk about the damages in a second, but the actual instructions up to damages on IIED, wrongful death, then go ahead and say it.
I have responses. Listening to his argument on the third paragraph, what he's really saying is he doesn't want you to read the sentence. In most circumstances, the law treats an act of suicide as unforeseeable and requires a person to be responsible for their own act of suicide. I just A, that is exactly what the law is, and B, it's critical for this jury making this decision to understand that that's normally the law and that they're working on an exception to the law. So I believe that that's very important. As far as whether an irresistible impulse is spontaneous, that's what Webster's dictionary says it is. When you go by the candy store and you just can't resist going in to buy the candy, it's an irresistible impulse. And this is a very different circumstance, but it's still the same. And moreover, their own expert, who I keep wanting to call Dr. Roberts, but his name is Dr. Richards, said that most suicides are triggered by an event that occurs within, I think his number was, the range ended at 72 hours. And so even their expert, I'm not sure where spontaneous ends, but says it's something that occurs because of a trigger that takes place in the near time period of the suicide. So maybe there's a lesser word than spontaneous, but the notion that it has to be something that isn't thought about for a long period of time is there. I mean, this woman wrote apparently 2 drafts of a suicide note, and then another one. We have 2 sets of these in, and she put together an elaborate way to do this. And the jury needs to know that that's an important concept here, because in trying to decide whether she could resist thoughts of suicide, she did an elaborate plan. So this is very important. And then on the definition, you're talking about the definition for concurring cause. And I've given you a memo. I probably have memoed you to death, but that has to do with damages rather than the causation of something like suicide. And so the fact that we have used it for many years in a combined jury instruction that was intentionally designed by that committee. I was on that committee. I know what they did on that. This is a case where we need something separate and distinct for the causation of a suicide as compared to the damages that flow from that suicide.
And on a side note, there was discussion a couple of weeks ago about not using the word irresistible, but I think it was uncontrollable.
Uncontrollable. I would still prefer that, by the way.
Yeah. So, Mr. Alligat, anything further, and then also maybe commenting on the word uncontrollable instead of irresistible?
Nothing further as far as the words go. I think the case law that we were referring to uses irresistible.
I know that the case law says irresistible, but
actually it's a mixture. Most of the cases that are under this intentional infliction use uncontrollable, but the FEL case that started it uses irresistible.
And I just wonder if the word uncontrollable is better understood than irresistible.
And in particular, because their expert tried to turn it into a psychological concept, I still believe uncontrollable is the safer word to use.
As long as we don't end up with the defense then arguing that our expert did not testify to that specific term, but rather irresistible.
Well, to me, the words are synonyms.
It is. I just didn't want there to be inevitable motions or objections coming from that judge. I'm fine with either one, but I tend to agree with the court that uncontrollable probably defines it a little bit better under these circumstances.
Okay. Anything else? Okay.
Sounds like I think Mr. Altmore wanted uncontrollable also, right?
Well, I mean, I'm at this point.
He doesn't want the claim.
I get that, but
as long as it doesn't change what it takes to be, it still needs to be a spontaneous thing that you do in this fashion. So I'm not changing the language other than you can change irresistible to uncontrollable, but the rest of it is what we need to have in there.
I'll make that decision ultimately up to the court.
Let's talk about the damage component. I don't think there was a disagreement as to the damage, but just want to make sure.
I don't think there was either. I talked to him on my computer.
You lost battery?
Yeah, no. I had to go back in and do the safety check on it. So, okay, I'm ready now.
So there's no disagreement as to the survivor damages?
I believe that's all standard language and accurately entered at this point.
Okay.
I think so, Your Honor.
Then the next issue is on pages at 43. And you want the primary contribution language again?
That's the only thing was the objection you have denied a couple times.
Yeah, I think that's probably coming out.
Well, and then finally on page 45, for the one with Beata Kowalski, it's not so important because it's survival damages. But 501A2, which they put in here, starts with any bodily injury sustained by, and that's really kind of backwards of this tort because.
Okay, I'm sorry. So we're on Maya's IIED claim now?
Yes.
Okay.
And it's page 45 of the top paragraph. You award damages for any bodily injury sustained by Beata Kowalski and any resulting pain and suffering. Well, this tort actually reverses those things because it's a tort for creating emotional distress. So it ought to be for any emotional distress and for any bodily injury. I mean, if they proved it, which I'm not sure they did, any bodily injury resulting from that would be what would happen.
Kind of like a physical manifestation stemming from the stress?
I'm not sure. I'd like to see the language and think about it, but this language is not it.
Yeah, I don't.
Mr. Elliott, any thoughts?
It's an emotional.
I don't think I have anything to add on this. We took out a reference to disfigurement as not being within the evidence. I don't think I have anything.
Is the issue here whether bodily injury stays in? Or?
No, whether it comes before or after the mental anguish, I think.
I think it's how to phrase it,
Yes.
and I'll think about it, and you'll see what I end up doing. Hopefully tomorrow.
I would hope and/or mental and/or bodily.
Well, okay.
So that takes us to 47.
Yeah, and that highlight was only I wanted to show you where the lawyer talking to witnesses is, and so it's going to be on page 47 in that spot because you didn't want to put it up front. And then the blue language is non-duplication language. I wasn't sure where to put it, but that seemed like initially I tried to put it up front, and that didn't seem like the appropriate spot, so I put it here. There's no standard language on this, but I've used language very similar to this on a number of occasions in the past.
How are we going to how is the jury supposed to take this when we are separating out damages for individual torts and be able to accurately comprehend where one starts and the other one stops? I do not agree with language other than a very general statement that to the effect that
This is a pretty general statement.
should not.
Well, I'm open to something more specific, but we've got false imprisonments and batteries taking place simultaneously, for example, and his whole goal is to maximize the damages by getting them to award multiple things over and over again. And these things, hospitalizations, that every time she goes in the hospital, it's going to be for all of these things, according to him. And so they have to have non-duplication so that they think through the fact that if we awarded hospitalization or lost wages for this last claim, how does that impact this claim? Because they go through this series by series.
I was always for the idea that if you took a set of damages and if any one of a series of causes of action awarded the same damages, you had those damages. The decision's been made. We're going to do it separately. I do not want the jury out there confused about, well, we awarded this much for this. Now, how am I going to separate the mental anguish from this? It seems like an impossible
Mr.
task.
Anderson, I need to rein you in, man. This is appellate talk. This is not in front of a jury talk. Let's just get this. Conceptually, I'm okay with the concept of non-duplication. I'll look at it a little bit more, but I think some sort of statement that Mr. Altenburn is suggesting is probably appropriate.
And I'm wide open to any alterations or changes you want to make on this, because again, it's not a standard one, and this case is more confusing than normal because there are so many claims.
And Your Honor, I would note that in the jury instruction, or excuse me, in the jury verdict form, I think we have a couple different ways of wording it maybe, but we have a non-duplication instruction in the verdict form.
Yeah, I've seen that. So is there anything else on the jury instructions? Because I think that was the last one that I saw.
Not to my knowledge.
Just to the best of your ability, you should avoid duplication or something to that.
I will have some sort of non-duplication instruction in there because I think it's important. And I think the jury needs some direction on it. That being said, I think we have now dealt with the jury instructions. Our next task would be the verdict form. I would propose that we take, a 5-minute or so break since we've been at this for an hour and 45 minutes.
Okay.
Any objection to?
No.
We have unanimous agreement that we're going to take a break, 5 minutes. He did.
Your Honor,
Hold on a second.
let's start.
I need to get my computer unlocked here. Can't even see you yet.
Okay, sorry.
There you are.
Could Mr. Whitney is out there somewhere in a waiting room or something? Could you let him in, because some of this damage, the damage questions that we have, he's going to be more familiar than I am.
I will promote him to a panelist.
All right.
It's not quite the military rank that I'm sure he's familiar with, but in Zoom lingo, that gives him almost all access.
Any promotion is good.
Mr. Whitney is in fact a commander in the Navy.
I'm aware. Doesn't he fly fighter jets or something like that?
He flies
Nothing that cool.
including
Not at all.
helicopters.
Helicopters.
50,000 parts going different directions at the same time.
In any event, there's
Anyway,
Mr.
happy to be
Whitney.
the panelist. Sorry.
Okay. Now, let's go to the verdict form. Let me make a couple of general observations. I don't think the following observations are going to come as a surprise to Mr. Altenburn, since he has had a previous case with me and he knows kind of how I like to format things. But I'm going to be very specific after each question what the jury needs to do, go to number whatever.
The directions.
Agreed.
And it's going to be very clear. It's going to add length to the verdict form, but the ultimate goal and hope is that there will be zero room for misunderstanding. Now, that's the goal. If when you see what I do, if you think it interjects any hint of confusion as to what the jury needs to do, let me know and flag it for me.
Yes, sir.
So I will, in the version that I hopefully will get to you Friday afternoon, that will be included. Now, I will also attempt to mirror the language that we use in the jury instructions on like medical care, nursing care, and all that. If I've pulled something out for a specific claim, I will try also to pull that exact same language out from the verdict forms, such that the two should mirror each other. Again, if I fall flat on that, highlight that for me. I do like the change back to kind of what I was thinking, that we would do liability for punitive damages right after false imprisonment, and then a separate punitive damage liability after battery.
It didn't work the other way when I.
I think it has to be this way. Now, I want to ask very specifically as to the following. We'll use false imprisonment as an example. There are 3 different instances of false imprisonment that plaintiff have claimed. The verdict form as it was presented by the parties would allow, if 1, 2, or all 3 are checked, yes, would allow for a singular damage line instead of a damage line for each specific separate battery. Is that what both sides are specifically requesting?
Yes, I've had discussions with my client about whether we needed to itemize everything and make the verdict form even longer for the jury, and the decision was that for false imprisonment, we would just have the economic, non-economic breakdown and not more than that. So that, and
Economic, non-economic, and then there's 768, in the past and to be incurred in the future.
well, yeah.
What's required.
Well,
The economic, and then you have non-economics, and the non-economics are divided further into.
Okay, the first question is
There, the compensatory damages are being aggregated for all issues of false imprisonment as well as separately for battery. I just want to make sure advertently that each side is requesting that,
It was not
because what I don't want to have happen is I don't want either side to say Judge Carroll did not have specific line items and there's no way in the world I could determine that, let's say the jury picks on false imprisonment 2 of them, and then the appellate court reverses as to one but leaves the other. I don't want the damage award coming back at me because of the lack of apportionment by claim. So I'm fine if both sides expressly say that that is what they want, and they're going to lose any ability to say that Judge Carroll did not give me a specific line item for that specific false imprisonment. And so I'm fine doing it this way, but I just need both sides to tell me that that is what they want.
Go ahead.
I'm thinking, because what you're saying is that if, for example, the second district held that there was no false imprisonment between October 18 and October 20th because of the fact that she was still in a room just like her other room and probably didn't appreciate that she was being restrained at all, then if they've checked that box.
Let's say they check the box, yes, there was a false imprisonment between October 7th and 13th, right. But no, there wasn't a false imprisonment for October 18th and 20th. Yes, there was a false imprisonment on January 6th. Let's say the second DCA cuts the January 6th finding but leaves the October 7th through 13th.
Mm-hmm.
The verdict form as read would not have a damage, so effectively it wouldn't matter if the appellate court reversed as to one, so long as there was one remaining.
And I think you're right, and as a result of that, I think I need to have separate damages for A, B, and C. I think it has to be laid out separately for each one.
Okay.
We object. We object. We think that, again, we're getting into this area of overlap, and we're willing to take the risk on this, that the damages overlap sufficiently in a category now of false imprisonment such that even if one out of them is eliminated, or even 2 of them are eliminated, it's not really going to affect the overall amount of those.
I'm going to separate and put additional damage lines because I think it's important to give the jury the ability to award damages for the specific conduct that it finds to be a battery, assuming that they were to find it. We'll definitely include some sort of non-duplication language. And that way it also gives the appellate court the ability to know what the jury was thinking. If the jury comes back with any sort of yes finding. I mean, if they come back with a no finding, it's a academic issue at that point.
Well, note our very.
I hear that you want less damage lines on the verdict form.
I just don't want. I think it's going to breed confusion. I think it's going to breed questions, and I really don't think, based on the history of Florida law, it's going to make that much difference because we always had in our verdict forms a number of different counts, and as long as there are the damages here, if there any one of them that supports that, there's a basis.
Well, I'm more of a fan of interrogatory answers, and more information in my world is better, and whether that helps or hurts, it kind of is immaterial to me. I want information. We ask the jury to make findings, and that's what I'm going to have them do. They'll earn their pizza or sandwiches that they get for their lunches and dinners.
And as a result of that, I'm going to need the same thing in battery for A and B.
Yes, sir. We will recast it such that,
Are we talking about this language?
No, he has ruled.
Sorry, on battery of Maya Kowalski, is that already determined? It's going to be and the other two employees? 2A?
Plenty of evidence.
well,
on that.
I was only talking about conceptually what I was going to be doing to
okay.
the verdict form.
All right.
I haven't gone to any specific language.
Okay.
In the jury instructions.
Was from a structural standpoint,
We have some non-duplication language down below.
I saw that, and I will. You'll see what I do, and again, I'm hoping to get this out to you all on Friday afternoon. That would be my hope. Now, let's go if there's specific language that someone needs to address.
Ms. Paul has pointed out something to me that would impact the language, the same language in the jury instructions, by the way, but she has a good point. The two other employees have been referred to in front of the jury repeatedly as the two bedside nurses, and probably would be less confusing to the jury if we called them bedside nurses rather than other employees.
The only testimony I'm aware of, Judge, on these photographs is that it was Kathy Beatty and a bedside nurse in the morning and Kathy Beatty and a bedside nurse when she came back. So I think the jury might be confused as to who you're referencing if it says Kathy Beatty and the two other employees. I don't know that they're going to connect that, and I think if we change that to bedside nurses, it would be clearer. It's my suggestion.
Okay, well,
We don't agree. There's evidence from Maya Kowalski about being dropped by.
This is
No, that's not in this case.
we're talking about the battery,
We're talking about the photographs.
the photo session or sessions.
Yes.
Her dropping in that room is
Two
not a
or
battery.
three.
Mr. Anderson, go to page 4, question 2A. That's where I think Ms. Crowell's is.
Yeah, I just think that could, they might, I think they're going to be confused by that. There's only been bedside nurses discussed as being in the room.
I am conceptually fine calling them bedside nurse, but here's a slight wrinkle.
Okay.
Maya Kowalski, again, has taken the position that there were not 2 photo sessions,
No, I
and that there was only one.
That's true.
But I guess she also talked about there was one photo session, but there were 2 different hands.
Yeah. But the second hand, she says, is Kathy Beatty.
Right.
So maybe it could be Catherine Beatty.
And the bedside nurse.
And any other bedside nurse.
And any bedside nurse. Or
Yeah, any bedside nurse, because we say it's 2,
she says
and she's
it's
1.
Yeah. Sorry, I didn't mean to talk over. Yeah, so maybe did Kathy Beatty and any bedside nurse commit a battery on January 6th? That makes sense to me, Judge. It takes out the numerical issue.
I like that.
We object. We're micromanaging the facts of this.
My job is to make a very clear instruction and verdict form. We're talking about batteries. The only evidence for the photo session, even from your own client, was Miss Beatty and the nurse. So I don't see why it's a problem to refer to it as a bedside nurse. And I like how Ms. Crowell's couched it so it also avoids the 1 versus 2 photo session issue. Okay. So I'll recast for that.
Judge, just in response to Mr. Anderson. Oh, I'm sorry. I retract. Never mind.
Okay. Are there other issues with language?
I think there's some questions, Your Honor, that Mr. Alton raised, like on page 2, on different elements of damages within within the economic and non-economic. And I think Mr. Whitney might be able to speak to that because I'm not as familiar with the evidence.
Okay, well, when we talk about the aggravation and that language, I was going to mirror it to what the jury instructions were going to say. Are there other issues that I need to address?
We took out the word disfigurement. I guess the simplest way would be if there isn't anything, the jury's just not going to award for it. I mean, they know what they've heard.
Judge, I'm sorry, we lost where you are.
Page 2.
It should line up with whatever is left in the jury instruction. And
yeah,
when you change that, if you can look at this, it should line up
Right.
with that.
That's what I was saying right at the beginning is
Yes.
I'm going to attempt to mirror what is in the jury instructions over to the verdict form, and that would be my intent. If I fall flat on that, I need you to highlight that for me, but
Right.
my intent is if I make the change over in the jury instruction, it should flow to the verdict form and mirror in the verdict form what is in the jury instruction.
I would note, by the way, on page 4, the blue and the red are the kind of two initial non-duplication languages that were being used. And there's something like that in all of the affected counts.
I'm not sure it did get repeated.
Okay. I will. You will see what I do if we need to take out some non-duplication language or add in additional non-duplication language. You will get that opportunity. So,
And Your Honor, what I was trying to do is figure out, and I really didn't succeed at this, figure out the red line is what we would propose, and to put it someplace near the beginning, maybe the first time, and then considering a second round of damages, so it doesn't get repeated all the way through there. That seems going to just make it longer.
and so if you want the red, the defense wants the blue.
I think that's correct.
Are there other language issues we need to address?
Yeah.
Ms. Carlos?
On the inner battery.
Wherever. Let's just.
2B. When it says, did Catherine Beatty commit one or other batteries on Maya Kowalski at other times described in the testimony, makes it a given that it happened.
Yeah.
I mean, that's saying, as described, did she do it? And so I think if there's going to be a question, I didn't think she was sued for any other battery other than the putting on the lap and the photo. So this makes it sound like she did it. So I think that at other times described in the testimony is endorsing that happened.
I was struggling with what to put there because this is the one that actually you didn't direct a verdict on for punitive damages. These are things that happened over the 100 days where she says she was touched and didn't like it in her room.
I think the only one was, I thought the only one seriously was putting on her lap and hugging her.
No, it's alleged as two different things. When we specified the points of battery, that it was alleged out to three things: the EEG room, which is gone, the things that were in the chapel or somewhere else that.
All right.
And
okay, I hear you. So, but can it just be, did she commit? I don't know, but
I'll look at it. I hear the concern.
Okay. Okay. All right.
Because I mean, it was the allegations are this took place in the chapel. I'm really flexible on that. I didn't know what to put down there.
If I could comment briefly, if the court would, when considering it, look at paragraph 79, we described unwanted hugging, patting, stroking, slapping, caressing, and kissing. Some of those things occurred in a room. Some of those things occurred in and around the vicinity of the chapel.
Yeah, so, I'm not looking to limit it to the chapel or her room. I just didn't like as other times described.
I'll look at paragraph 79, and perhaps if that is a complete roster of the allegations, then we'll substitute that roster of allegations. But what's next? Are there other language issues as to any
I think on toward page 6, Your Honor, the med mal, it's the next one I have. Under C, I was concerned about a little confusion there. Health providers other than Sally Smith, for whom John Hopkins is legally responsible, and you see the comments out to the side. It admits it's responsible for all others. So I don't think we need the for whom it is legally responsible in there.
I'm not following what you're asking me, Mr. Elliott.
6C.
No, I'm there, but what are you trying to get me to say?
I think delete the language beginning that says for whom John Hopkins All Children's Hospital is legally responsible. Because that's redundant, because they're
It needs to be.
I understand the response. No, sorry.
My apologies.
I thought they were admitting they were responsible for everybody, for all the healthcare providers other than Sally Smith.
Well, it needs to be not Dr. Hannah or Kirkpatrick. I mean, it needs to be tied to John All Children's Hospital.
Well, that's the only claim, right?
Well, the testimony's been, though, about other doctors doing other things. And
But they didn't see her in the hospital, did they?
okay. They didn't. I just want to make sure the jury's interpreting the question to be during the hospitalization. And you know.
Maybe that's the way to say it then.
Well, what about one or more healthcare providers employed by Johns Hopkins All Children's Hospital? Because all these other people that we're legally responsible for are actual employees.
Well, but then figure that out.
Yeah.
Or one or more healthcare providers employed by Johns Hopkins, comma, other than Dr. Sally Smith, which gives the impression that Dr. Sally Smith was employed.
Yeah, we don't want that.
Yeah.
How about just say during the stay? I go back to what Ms. Kralls was mentioning earlier.
Well, I can't give an impression that Sally Smith was employed by Johns Hopkins, especially since I'm telling the jury that she wasn't. That the only question is whether she's an apparent agent.
Right. I think what Ms. Kralls was saying in C, if we took out the for whom John Hopkins is responsible, but put in there someplace during the stay at John Hopkins All Children's Hospital were one or more of the healthcare providers other than Dr. Sally Smith negligent.
Okay, then how about, from a conceptual standpoint, if the jury checks the box that Sally Smith was not the apparent agent, then there would be like an instruction, a sentence on the verdict form that says, for this next question, you may not consider any act by Dr. Sally Smith. And then do was there one or more healthcare providers were there one or more healthcare providers negligent in the medical care of Beata Kowalski, something like that. So if the jury has just checked no, that Sally Smith is not the apparent agent, the very next question that they would have to answer would be inclusive of some sort of instruction saying they can't consider Dr. Smith for it at all.
I think that's what happens with the way, if they work through it the way it is now, the way Mr. Altenburn drafted it. I think the only confusion is in paragraph C.
I mean, if Your Honor would like to try something so we can look at that I understand what you're going at. It occurs to me while we're discussing this, I don't know how Mr. Anderson plans to argue this, but we might need to say, other than Sally Smith and Catherine Beatty, if there's going to be any suggestion that she was a healthcare provider, because she's not.
I think we might need an instruction that Kathy Beatty is not a healthcare provider.
I think you have flagged the issue for me, and you'll see what I do. And then you can propose alternative language if you feel if I fall flat. Anything else on language?
I was unclear on page 7, the blue.
Oh, well, maybe that was me being tongue-in-cheek.
Probably not appreciated right now. What's that?
So I think I can delete the...
Yeah, your rulings are such that you can delete that.
And I think that then with the instructions, if you down on the next thing under 4, you harmonize that with the instructions.
That's probably a better word than mirror, so harmonize. I will attempt to harmonize. I would harmonize number 5. Are there other language concerns?
Page 10 or something?
That's just conforming to the damages, I think, right? But page 11 does have...
I note that in 6 on fraudulent, this says fraudulent misrepresentation. It should be fraudulent billing. Well, it is a fraudulent misrepresentation count, but Mr. Elliott never put a damage line in that one, and I did not either.
Okay.
Should we change it to billing? That's the only thing the jury's
Yeah,
heard
they've
about.
heard billing.
It's going to be billing.
Yeah.
Okay.
But and then I'm not quite sure how you're going to do the damages on that.
We'll see on Friday. See when I get it finished.
I think on page 11, that'll need to be reworked in light of the rulings on the instruction.
Right.
But Your Honor, I think one thing we agree on, we talked about yesterday, is that there would be one line for uncontrollable and one line for substantial factor. One question for each of those.
Yeah, so an interrogatory option, yes or no.
Yeah, and it's set up that way now. It just needs to be reworked or harmonized.
Anything else?
Not sure.
But I don't think so.
Just the lines for the damages are not big enough to put a letter in, let alone...
I'll make them smaller.
We agree.
This was a rough formatting. Okay.
Yeah. There might be humor involved in that.
Judge,
I can negotiate the length here.
Judge,
But I'm not going to make it landscape to make it an 8-inch line either.
It only needs to be half the page, Judge. It will be fine.
Judge, outside of this issue, there's one exhibit issue that needs to be resolved, and I see Mr. Whitney's here.
Is there anything else on verdict form before I pivot to something else?
The only thing I would kind of highlight for you is that from intentional infliction survival, your instruction on where to go next, I've done a bit on that, but it's a little complicated because if they answer no, they jump all the way to Maya's intentional infliction, and if they answer yes, then they go to the next one. So that just needs to be done. I think I got it, but you may think it could be done better.
Wait a minute now, because they should be answering both survival and wrongful death.
Absolutely.
No. If they answer no to survival, they don't get to wrongful death. That's what our instructions tell them.
Oh, you're talking about the top of 7.
Right. If there's not enough emotional stress to cause survival damages, then there certainly is not enough to cause wrongful death. So you jump on those. Now, at the end, if you get both, you're going to have to elect. I think I know which one you'll elect.
Elect afterwards. Yes. Okay. Sorry.
Okay. I knew what he was talking about.
I'd rather have them both answered.
Anything?
No, there's nothing more from our side.
Tom?
And to confirm, you're also going to read and give them a physical copy of the dependency order instruction that was done before. We weren't asking for any changes in it.
That was my intent.
Okay.
Oh, okay. I'm sorry. Is that going to be read again? The 10-page thing?
Yeah.
I thought that was just going to be given to them.
Well, I guess theoretically I could just give it to them.
I had told you before that I maybe you should defer to trial counsel on this, but it's going to take a long time to read these things. They've heard it once, they know what it is, so as long as you tell them that it's there, and if they need to read it again, it's there, I'm not going to object.
It's a 10-minute read, so it's not the end of the world, but it does take some time.
We had a couple of additions to the dependency orders, Your Honor.
Well, send those to me. Specific language that you were asking or to be deleting. I think I had circulated the Word version of what I actually read. I believe I did.
You did. And if they have additions, I haven't seen anything about that to this point.
It's going to be so much easier if you send like a legislative style, add this language and strike out this language to the actual physical Word document. It's so much easier to see what it is that you were asking for, or whatever the issue is. So please do that, and then let's talk for a moment as far as timing, and then we'll pivot to some of these other issues. My hope is that I will be able to get to the lawyers sometime late afternoon on Friday. My goal is to get my draft of the instructions and the verdict form to you. It all depends on how long that meeting goes and whether I have Wi-Fi in Wesley Chapel or wherever if I have to pull into a Cracker Barrel or something to grab someone's Wi-Fi, I'll make it work somehow. It's just I don't know when I will be able to do that. But my goal is to get it sometime Friday afternoon. Assuming I can get it to you Friday afternoon, would you be able to get to me any suggested changes, additions, alterations by let's say 3 o'clock on Saturday?
I have no problem doing that. I would want to confer with Ms. Crawls if you're going to be available. Yeah, that should work fine.
And then I would try to get back to you any sort of further comments to your suggestions or rulings, or by, I would say, hopefully around noon on Sunday.
Okay.
And then if there was anything further, that you would get it to me by, let's say, 8 p.m. on Sunday night, so that I'll have those last minute points, so that when we walk in on Monday morning, they should be pretty much finished, with maybe possible, a nit here and a nit there.
And my only concern at all is that I know Mr. Shapiro on our side and Mr. Anderson on the other side are preparing closing arguments and displays for the jury and whatnot. I don't know how much, if we do too many changes on this in this time period, it may impact people's adjustments to their closing arguments.
My hope is
I'm betting by 3 p.m. on Saturday we have something close. That's what
I think that, and then on Sunday, when I forward something at noon, we're probably going to be relatively close.
Yeah, if there were substantial changes at 8 o'clock on Sunday evening, I have a feeling I'd hear from Mr. Shapiro about that.
And by giving you the opportunity to file something at 8 o'clock, that doesn't mean you need to. It's just,
Right.
it's just if there was something else, so that I'm not caught flat-footed Monday morning, because Monday morning is going to be tough enough as it is.
Yep.
Okay, so any questions on the timing before we pivot? Okay, so let's pivot. Ms. Croyles, you wanted to talk about something?
Mr. Whitney, you're there. It's the one exhibit. We have a couple minor exhibit things we're working through, but this one, the plaintiff has admitted, and they want to redact some things that we disagree with significantly. I don't know. Can you put up? Are you set up to put up an exhibit number? 2408.
If I could jump in for a minute, if it's all right, I think I'm done. Your Honor, if I'd be excused, I've got to get to that seminar. Thank you. Thank you for your time.
Do you have the highlighted copy from Mr. Whitney that you could show what he wants to redact?
I'm not sure what page on 2408 are we referring to.
Okay, so I can just describe it, or Mr. Whitney can. But I received if you can put it up. I received an email from plaintiff's counsel highlighting what they want to redact on this, and we disagree because we think they're all admissions with respect to things. So,
What page on 2408?
oh, I'm sorry, 1738 and 1739. So this is in evidence, Judge, and then you may recall plaintiff said, oh, wait a minute, we want to redact some things after it's already been admitted. They want to redact starting from on the first paragraph. A woman from CPS showed up to the end of that paragraph. I don't know if you want to just take them one at a time. But I do think it's important you read it in context.
Doesn't that go to her knowledge as a parent agent?
Yes, exactly.
So that's going to stay in.
The next one they want to redact is on page 1739, the paragraph, it's the first beginning paragraph, Tuesday, M. 1011, that paragraph. They want to redact. Obviously, at that time, Dr. Bose or one of her associates already notified CPS but didn't tell us anything about it, so we were blindsided again. I'm less concerned about that.
Is this, just so is this, so this is on the 11th, this isn't on the 13th?
Correct. That's the only sentence they're asking to redact on that paragraph. The one that starts with obviously at that time, Dr. Bose.
Oh, so they would leave in the 10 people in the room and police officers in the hallway?
They want to leave that in, yes.
Mr. Whitney, what's your thought on that?
Yeah, the overarching goal of these redactions is to keep out Chapter 39 issues. So this is indicating a report or another report. The jury is aware there's a report. The court's made a legal determination about there being a reasonable suspicion. So the reporting of Dr. Vos is not for the jury. And you all are moving quickly. I'd like to go back to the first paragraph. We don't have to do it right now, but at some point.
Well, I'll give you an opportunity to say what you want to say, but that first paragraph goes to Beata Kowalski's knowledge relative to Dr. Sally Smith and the apparent agency issue. So I'll give you an opportunity in a moment, but
sure.
I'm pretty confident on that one. Now, on this Tuesday AM paragraph, I don't see, Ms. Crowell's, what that sentence that Mr. Whitney is trying to have redact, what issue that goes to or defense that goes to. It just seems an unnecessary reference to the Chapter 39 process.
Well, I think the context is important for her comment about there were police officers in the hall and security person. It's not, they're not saying the police officers are there because they want to leave against AMA. They're saying they believe the police officers are there because it's been reported to CPS. So we're fine if we want to take out the comment about there were 2 police officers in the hallway and security person, because she then says, obviously, they notified CPS. It wasn't.
But the problem is, I've already instructing the jury that it wasn't until the 13th. So I don't see how that sentence gets you anything.
Okay.
And so I would agree that that sentence comments on a Chapter 39 issue. So I am fine excising out the obviously at that time sentence.
All right. The next one.
Hold on, Mr. Whitney, say what you want to say about that page 1 comment.
Yes, Your Honor. Thank you. Page 1, it says a woman, says women, but grammatical error. A woman from CPS showed up here. It does not identify that woman as Sally Smith. If you look at the second page, it says the same woman from CPS came back. I'm sorry, I'm kind of jumping around here, for Your Honor. I don't think it's clear on the first page that the woman being referred to there is Dr. Sally Smith. So that sentence, a woman from CPS showed up here, I think it's unclear. And the next sentence, we were totally blindsided. Understanding the court's view on that piece as to apparent agency, I have a bigger issue with the next sentence, which is we questioned what this is all about, and we were informed that this is a standard procedure in ICU when a child is on so many different medications. And then it goes on to discuss the laws in Florida being different than Illinois.
Well,
so
my understanding was Ms. Crowell was only talking about that one sentence.
Oh, no, I'm sorry, Judge. No. They wanted to redact, I thought I said the entire sentence after that, a paragraph after that.
I just thought it was that one sentence.
No, I'm sorry. They wanted to redact, let me make sure it's clear on the record. The plaintiffs are requesting to redact the remainder of the paragraph, beginning with a woman from CPS showed through and her meds.
Well, that's a different.
Okay.
So when you say this paragraph ending, tell me, Mr. Whitney, where your paragraph, what you claim the paragraph, where it ends.
Yes, Your Honor. We would request that it be redacted from we questioned what this is all about all the way through. There were a lot of questions regarding Maya's RSD CRPS diagnosis and her meds. We believe the entirety of that goes to, first, a legal conclusion, secondly, Chapter 39, and invades the court's ruling about there being a reasonable suspicion, and the jury doesn't need to consider that. And then the questions regarding Maya's RSD, CRPS diagnosis, and her meds goes straight to, if it's believed that this woman was Sally Smith, to her investigation and report, which have been kept out at all other times.
I continue to believe that the sentence, a woman from CPS showed up with 2 police officers to investigate what's going on, needs to stay in because it does speak to the apparent agency issue. But as far as the rest, Ms. Crows, do you want to say anything?
I do. I think I understand maybe that we questioned this thing, but the sentence, anyway, CPS questioned Maya independently, then Jack and me, needs to stay in because that's, again, indicating that they knew the woman was from CPS. And then there were a lot of questions about her RSD, CPS diagnosis, and meds. That's Sally Smith. So if you want to take out the middle of that, we questioned through different in Florida. I don't care. But anyway, she questioned Maya independently, then Jack and me is clearly referencing Sally Smith.
I can agree that anyways she questioned goes to apparent agency. The next sentence, however, there were a lot of questions, goes straight into Chapter 39, her investigation, her opinions.
I will agree to redact the paragraph starting, we question what is this all about, through the remainder of that paragraph, which is laws different here in Florida, ? So that comes out. The sentence, anyway, she, CPS, question Maya independently, then Jack and me stays in. The next sentence is out.
Okay. All right. I think I have a hard copy of this. I should have been making notes.
I've got notes. I'll recirculate.
Okay. Thank you. Thank you, Mr. Whitney.
Okay, anything else on
Yes,
page 1?
No,
Mr.
not on
Whitney,
page 1.
because-
Not on page 1.
No, Your Honor.
Okay, so I've already ruled about something on page 2.
You did. You ruled on the paragraph that begins Tuesday AM. You have deleted or redacted. Obviously, at that time, Dr. Vose are one of her associates. Yes. That sentence.
What else on this one that's in dispute?
The next paragraph that starts Tuesday, 10/11, late afternoon. Mr. Whitney would like that sentence.
Well, I can modify based on the rulings that are being made here.
Okay. Well, go ahead, Mr. Whitney.
I would agree that Tuesday, 10/11, late afternoon, the same woman from CPS came back because of I don't know what CO is, from hospital staff. I think it should end there because the next clause, she received, I don't know, CO, that we wanted to take Maya AMA and to take her home. That's a lie. That goes to the Chapter 39 reporting.
I think that goes to the false imprisonment claim.
Yes, exactly, Your Honor.
So that sentence has to remain in, Mr. Whitney.
All right, understood. The next one, Your Honor, is if you move down halfway down that paragraph, it begins Tuesday, 10/11 evening. I have another supersized visit from Sally Smith. All right, I need to read this to myself for a moment to decide if consistent with the court's rulings, it's going to remain. I think that first sentence, supersized visit to investigate this child abuse neglect case, would stay consistent with the court's rulings here. But then I think the 1.5 hours and the investigation and the questions she was asking and how are these administered, all of these things are straight into Chapter 39 and Sally Smith's investigation report, which has been previously excluded. So I would suggest that the balance of this section from I spent 1.5 hours down to the end where it says when she first spoke with me be redacted.
My only comment on that, Judge, is I believe Dr. Smith testified that she spent, I could have this wrong, but I thought she testified that she spent 1.5 hours with her. So it'd be clear that this would be the same visit that Dr. Smith talked about. So we could just say, I spent 1.5 hours with her and end it there if the court is concerned about the rest being a description of her investigation.
I'm not concerned about the sentence, I spent 1.5 hours. it also reinforces the question of apparent agency. So I would excise in this paragraph, starting with she, Smith, asked a lot of questions.
And to where, Judge?
I think it goes all the way to when she first spoke with me.
Well, if we're arguing that this is all relevant to apparent agency and her role as a treater, then I'd like to keep the last sentence. FYI, she didn't know anything about RSD CRPS when she first spoke with me.
Well, that goes to the investigation, Judge. If we're going to leave that in, we got.
Well, I mean, to be fair, it is a statement about her knowledge base, and there is a question of apparent agency.
Okay.
So I would leave in the FYI. So I would redact starting with she, Smith, asked a lot of questions all the way through with her presence and will be questioning you. Anything else on this exhibit?
And then the last one, Your Honor, and thank you for your patience, is in that very next paragraph. Today went through Wednesday. Someone from CPS visited Kyle. Then CPS showed up unannounced at my home. I think those are Chapter 39 issues.
I don't think that can come out.
That's it, Your Honor.
Okay, Nick, you'll send that to me shortly, so I have it in my head.
Well, time out.
Sorry.
What about the next 4 or 5 lines? I think the ICU person who reported us is doing this.
Oh, yeah, that needs to come out, Judge. Thank you.
Well, no, I disagree because the jury is aware of the reporting.
But that goes to directly against the judge's ruling that it was done in good faith or reasonable cause.
And
it's not an issue for the jury.
All right, go ahead, sir.
Go ahead, Mr. Whitney.
I understand if that's and it seems like the court's leaning that way, then I think it should pick back up at, I cannot tell you how devastating this is to us, Dr. Hanna.
That goes.
I'm okay with that, but we need to take out the sentence starting with, I think the ICU person.
Yes.
All the way through Munchausen by proxy.
I've got it.
Okay, and so, Madam Clerk, how do you want this presented? Do you want this as an A, or do you want it as a separate trial exhibit number?
Is that replacing what we already have admitted?
Yes.
Okay.
But we need the unredacted version so that it can travel with the appellate record. So
Okay.
do you just want to just make this 1738 and 1739 as marked for identification and just have an A?
Yes, sure.
So would it be 2408A, 1739 and 1738 and 1739? The A goes after 2408? Okay.
Does it go after the 2408 or does it go after the 1738?
After the 1738.
Okay, so
Okay, so 1738A and 1739A
okay.
will be admitted, and the A version will be as redacted that we just, and then the regular 1738 and 1739 will just be ID'd but not admitted.
Thank you, Your Honor.
Okay. Mr.
Anything
Whitney,
else?
can I just ask Mr. Whitney a question real quick,
Sure.
Judge? I know you've got a lot of things doing, but can you get that to me fairly soon? Because I want to look at it while I didn't take good notes. Well, it's fresh in my head.
Sure. We'll have it to you within an hour.
That'd be awesome. Thank you.
What's the next thing, Ms. Cross?
I don't think there's, I can be corrected, but I think otherwise the exhibits are in good shape. You're missing a couple things, right?
Yeah, I believe as of today's date, we're missing 2 exhibits.
That we're going to get to you by Monday.
Right, and then we're missing
Oh.
a couple from the plaintiff.
Yeah.
I don't know what else is going to come in Monday morning. Maybe.
And also, do we have the Excel?
Yeah, I didn't give her the actual Excel till it's finalized. I just gave her printouts. not the actual thing. But,
Can I get a,
oh, yeah, I have an extra copy, Judge.
thank you.
But my other question is, I haven't heard any feedback on the language, so I'm assuming we're fine with the description of the exhibits. I don't want to be told Monday morning that we need to change the description of the exhibits.
I looked at it and initially it looks fine.
Okay.
I want to, if we have some additional questions on it, we'll give you a call, let you know in the next couple hours.
Yeah, as long as I get it by sometime Friday, so I get some assistance in correcting it.
And I do want to get out of here and start back to try to figure out how I could possibly put all of this into a closing, but not to say it'll be
You have way too much time. You've got 3.5 days for just 2 hours.
I don't even figure out the jury instructions for 3.5 days.
I just remember the old days when we'd go from last witness to closing based on sticky notes I made.
Exactly. Judge, I had.
Well,
go ahead.
Was there anything else, Ms. Crowells?
No, I don't think so, Judge. I'm going to hand you this copy, but I will note.
It's a copy, I know.
It's a copy. I mean, it's on.
Did you go to question 3325?
Oh, yeah, I was going to check with my co-counsel. I didn't think 3325 had been admitted, but they say it has. I was just going to check with my co-counsel first. I may be totally off base on that. And we know this column needs to be made a little wider because it cut off some numbers. Okay.
I just needed to drop this.
You can always wrap the text for
it just needs to be made slightly wider, Judge.
But I'm talking about for the column to the right, the description, you can wrap the text so that if necessary, you can go to 2 lines.
Yeah, Allison's got it. She's rapping. So I'm just trying to find that extra copy.
I feel like I have shown incredible restraint about not taking over the Excel spreadsheet.
I've been impressed with the restraint.
I don't have it.
Oh.
I don't have it.
So I think Ms. Crowells is finished with her stuff. Mr. Anderson.
All I wanted to do, Judge, the reason I've been hanging around is I wanted to deliver to the court and perhaps mark for identification a letter, January 31st, 2019, to Kevin Sowers, interim CEO, Johns Hopkins All Children's Hospital, that deals with the 2018 report and the results of it. And we are hopeful, although we haven't received it in time, if I may approach and give it to the court.
Well, I don't want to get into that, Judge, without.
If there's something you want me to read ahead of time, just give it to me. But file it separately with the clerk because I don't have time to have the clerk mark it and me get a copy of it because I need to get out of here.
Yeah.
So whatever you're giving me, I'm not putting in the court file. You're going to have to separately file with the clerk what you're giving me.
I will.
Now, has the defense seen what you're giving me?
Yes, I gave him a copy.
Judge, I don't have an extra copy right now because I wrote on this one. I need my notes.
Okay, well, Natalie,
I can email you one.
can you make a copy of the? Natalie's just going to make a copy of the Excel spreadsheet, and she'll get it to me in a couple moments.
Yeah, I gave 2 up there, Judge. Okay.
Your Honor.
Mr. Whitney, you're next.
And I'm going to bug out, so I'll. You looking?
You might want to hang for just another moment. Right. Mr. Whitney.
Yes, Your Honor. If I could just comment on what Mr. Anderson just delivered to you. I won't go into the detail. My question is, at this point, we have been delivered some documents regarding this Joint Commission issue. We have not been provided all of the documents that would exist, including the critical September 2018 immediate jeopardy report, audit, finding, however you want to classify that. So the question to the court is, recognizing it's Thursday at 11 a.m., how would the court like us to address this issue if we believe that there are insufficient documents being provided?
I was going to read what's been provided. Was the CMS notification 13119, the CMS survey 11119, the final accreditation report 81418 to 81718, gets them done recommendations 62619, and the CMS revisit survey 22119 final.
I didn't hear the self-report in there. I mean, here is, and I want to be very clear about this.
Okay.
I am interpreting my instruction to turn over stuff very broadly.
Okay.
Very, very broadly.
Okay.
If there is a scintilla of odor, it needs to be turned over.
Okay.
And when I say scintilla of odor, anything having to do with the run-up to this report, all self-reports, any prior surveys by the Joint Commission / CMS, because I heard that Mr. Hunter say yesterday, well, there was a prior triannual survey that we passed with flying colors.
You want that? How far back do you want to go, Judge? Because
Well, let me ask this, and maybe you don't know this.
I might not.
Did anyone lose their job over this issue? Like, is this when the hospital president
My understanding
no longer
is
became hospital
because
president?
of the heart issue that there was some. Yes, I vaguely understand. Keep that with a grain of salt. I vaguely understand that as a result of the heart issue, there was a cleaning of house, so to speak.
Well, yesterday, Mr. Whitney said that the documents say that it was not confined to the Heart Institute and that it was systemic. Now, obviously, I'm not in a fact-finding position at this moment, but
Yeah.
I need to at least assume the possibility that the reports are going to show more systemic than just heart-related. I mean, that's, I think, what the plaintiffs are telling me that the media accounts are.
I understand that's the allegation, Judge.
Okay, so knowing that I'm not making a finding of fact, but it sounds like there's an allegation, and perhaps the media also have made statements that it's not just the heart. I don't know.
Just saying.
This thing just kind of got dropped on me yesterday.
And all of this,
But-
these events are taking place after the events in this lawsuit.
Well,
right?
I'm about ready to get there.
Okay.
Because it does sound like the chief executive lost his or her job over this.
I believe that's accurate.
And so when did this chief executive start being the chief executive? Is this when...
Start being the chief executive?
Yeah, is this when Johns Hopkins took over All Children's Hospital?
I don't know the answers to these, but I'll take the notes.
Because if we're talking about something that is systemic, something that becomes pervasive and systemic doesn't happen just overnight. It's a culture that is created. And so is it when this president came in, is it when Johns Hopkins took over the All Children's Hospital? Is that when the systemic problem started?
Judge, my understanding is that I forget the acronym of the organization that.
Joint Commission?
Thank you. Joint Commission. That the Joint Commission report, I mean, they're looking for the documents, but that the Joint Commission report that was done in 2018, that they passed. And it was after that the hospital self-reported the issues with the heart stuff.
Well, let me ask you this. Was there media accounts that predated the hospital's self-report?
I don't know the answer to that.
Meaning, in other words, did the media bring this to the attention and then the hospital self-reported?
I don't know the answer to that.
But in my mind, if this is an issue of systemic hospital problems, and again, I don't know, I haven't seen any of the reports, and all I'm going on is what I'm hearing in court. But if there is a systemic problem, if this president lost his or her job because of this issue, I kind of want to know when that president became the president. Because if we're talking about a creating of a culture, the inquiry, does the creation, or does it start with that president? I don't know.
I don't know, Judge. I think that this is sort of going off the rails a little bit. I mean, the issue in this court for this jury is about whether or not, as I understand it, when the testimony was given, that this hospital passed the, I'm sorry, the name keeps escaping me, the
Joint Commission.
Thank you. My God, I'll write it down. When this hospital, when there was testimony that they were accredited by the Joint Commission. And then there was an issue raised by the plaintiff, but that ain't true. They, in fact, were on this double secret probation or whatever. And so that's what started this, Judge. And so now it's become a deep dive into years and years of this hospital.
Well, I
and
think
so
what started
if the
is
Joint
when the
Commission,
I think what started is when the defense presented evidence before this jury that says that the Joint Commission had blessed Johns Hopkins All Children's Hospital, giving what possibly is a very false impression.
well, Judge, so that's,
And not just the Joint Commission, also federal agencies.
so that's the issue. So if in fact the Joint Commission in 2018, which would go back over the years that are involved here, passed the hospital, and then it was only after that that this issue came up with the heart stuff, then we were in fact accredited in 2016, 2017 when this is the thing. So to go back and deep dive into the whole hospital seems a little extreme for the issue that this is addressing.
Well, I just fundamentally
I can answer a couple of the courts.
Okay.
I feel very strongly at this point that a deep dive is not only necessary, but is required, and I'm directing it.
Okay, so I don't
It has to happen immediately.
I understand. I'm just not clear what the court is asking for with respect to time frame and also what documents.
Well, again, I'm asking when did this president become president? I don't know the answer to that. But if we're talking about something systemic that was a culture that was pervasive through the hospital, then I need to know how long senior leadership was involved. Because if we're talking about the creation of culture, it generally starts from the top down. Now, sometimes it's bottom up, but that seems to be something that I need to know.
But isn't the first threshold question, was it systemic? Before we have to dive deep 20 years or however many years this guy was president?
Well, how am I going to make that determination?
I think the reports would make that determination and the deposition on Friday.
And I don't have any more hearing time between now and when we walk in on Monday.
Well, I feel like I can't address the court's concern. I do not have the knowledge as to when this guy became president.
Okay, Mr. Whitney, when did this person? Well, who are we talking about first? Who's the president?
Jonathan Ellen. He was brought down from Baltimore after the acquisition.
When was the acquisition?
The acquisition, I believe, was 2011. I might be wrong on the date.
It's 2011.
Okay. So when Johns Hopkins All Children's Hospital took over All Children's Hospital, the fellow who lost his job became the chief of All Children's Hospital. Is that what you're telling me, Mr. Whitney?
Yes, Your Honor, except I can't represent that he immediately became the president at Johns Hopkins All Children's Hospital upon the acquisition. I can only represent that between the time the hospital was acquired by Johns Hopkins and the time that Beata Kowalski was a patient there, he had become the president and was the president during the relevant admission.
So I can find that out, Judge. Obviously,
so why don't we do this? Whenever that person became president,
2012. 2012.
That's the date range.
And you're looking for the Joint Commission reports from that date forward.
And the federal agencies, however they interact with each other.
Okay, I'm not trying to be difficult. That's kind of vague, but I'll report it.
I am doing the best I can. Again, I am going to take a very broad view of discovery. So if there's any hint that it might be relevant to this concept, it needs to be turned over. I am going to look on very disfavorably if I come in on Monday morning and I get I didn't get this report from 2017 because I didn't use the proper language in my discussions. Because
I'm hearing the court, Judge, and I'll do my best to articulate this as described.
Your Honor, if I can inquire only because I kind of missed how this became a thing in this trial. Very quickly, does this relate to the punitive damages for false imprisonment and battery? Does it relate to the negligent training? I'm not quite sure I understand why we're doing this. That's all. I just don't know what issue it triggered all of this. I'm just trying to figure out.
Well, what triggered all this is the defense presenting an impression in front of the jury that the Joint Commission has blessed Johns Hopkins All Children's Hospital and basically said everything was fine. And that possibly is either a correct statement or a materially false statement.
Okay.
Very materially false statement.
All right, I understand the court's directives.
Anything else on this issue, or can I?
As long as we have some date certain, time certain today by which we would know something.
Well, I don't know what that means. I think
we've got a deposition tomorrow, right?
I would say that the court's comments have expanded the materials that we thought we were producing. So I need to get that information.
I'm not sure I expanded it. I just was.
Well, we went back in time.
Enforcing it.
So.
We have to have a little bit of time to go through these documents before we depose them.
I've said what I'm going to say on it. It's an expansive, given the position we find ourselves in and how this came up. So let's talk about how Monday morning is going to shake out.
Yes, sir.
Because I also, am I getting a motion to disqualify one juror or two jurors or three jurors? One juror. Okay. And that's going to be filed today.
Yes.
I want to first, when we walk in, I want to first address the imminent jeopardy finding issue.
Okay.
That's going to be the first thing we're going to do. And any sort of follow-up. My hope is that if there's any further testimony that has to be done, the plaintiffs are ready to bring it. So we can end this case, a few minutes after we bring the jury in. The second issue I think we need to address will be the juror issue.
Yes.
And whether we do that before or after the jury, I don't know. It just depends on how long it takes us to deal with the first issue.
Understood.
And then the next issue after that would be if there was any sort of remaining jury instruction issue, we'd probably have to address that issue as well. My hope is we won't have anything at that point. Do either side see anything that we also have to address?
So long as the admission of additional exhibits falls within that first category of discussing immediate jeopardy, no.
When you talk about admission of additional exhibits, I mean, is it going to be tied to either the initial jeopardy issue or that one policy that we talked about yesterday? That's what you're talking about?
That's what I'm talking about, Your Honor.
Yeah, because I'm not seeing this as we're just reopening up discovery or evidence on other issues, because that's not what we're doing.
Understood.
Okay, anything else on that?
I think so.
No, Your Honor.
Okay. Thank you all very much. I will see everybody on Monday, but I'm sure we'll be in communication via email over the next few days.
Thank you, Judge.
We are in recess.
Thank you, Judge.
We have all of the